I'm Robert Chisholm. This is Kerry Baker. We're going to be talking today about claims for post-traumatic stress disorder with the VA. Many veterans will come to our firm and say the doctor, the psychologist, the psychiatrist has diagnosed me with PTSD due to my service. Why isn't that enough?
It could be enough in some circumstances, but in a lot of cases, if that veteran cannot show that he or she was in combat and that the events took place as they described, on which the doctor based the diagnosis, then VA doesn't have the required stressor or combat evidence in order to service connect that disability. That's one of their requirements that they need to see in addition to the diagnosis.
Kerry, are there any publicly available records that veterans and claimants can use to show that the stressful events in either Iraq or Afghanistan actually occurred?
There are now. As you know, and as many people in the military know, the military's always kept records of combat events. But those records may not be in that veteran's personnel file. It may or may not even be in that unit's after action reports, right? But not long ago, we come across one of the DoD's FOIA websites, FOIA meaning Freedom of Information Act, and most of your DoD components are supposed to keep a FOIA website so that when someone submits a FOIA for certain information and it's the type of information they release under that request, they're supposed to keep that in a location where the public can see it, so that if somebody else wants that info, they don't have to keep asking for another FOIA request. So having said that, we found one of DoD's FOIA websites where somebody had requested basically evidence of all of the combat events, the IED attacks, any kind of combat event that took place for a number of years in Iraq and Afghanistan. And sure enough, it lists the attacks, whether they be an IED attack or some other type of gunfight, whatever it may be, down to the date and time and location for years.
Were many of these claims denied in the past when veterans applied for VA benefits for post-traumatic stress disorder post 9/11?
Well, that's a good question. We recently have done a FOIA and requested information from VA on all of the post 9/11 claims for PTSD that were denied because of no stressor. And the result we got back was close to 100,000 claims, starting in 2003, actually, realizing that it's going to take some time for the combat to take place, a veteran to serve in it, get out of the military, file a claim. So starting in 2003 up to the present, there's been roughly 100,000 claims denied because of no combat stressor.
So from 2003 till present, September 2017, over 100,000 claims were denied because the veteran didn't have evidence, or the VA wasn't able to obtain evidence of the stressor event.
That's correct.
So let's suppose I'm a veteran and I have been denied, say, in 2005. And I look at my decision and it says we can't prove the stressful event happened. Is there anything a veteran like that can do today in September 2017 to refile that claim?
Yes, they need to reopen their claim, which is simply done by initially filing the application for benefits like they did initially. And then they can go on this website and obtain this information of the combat incidents that took place, show that to VA, submit it to VA in support of their claim, and that should serve as what VA calls new and material evidence to reopen that claim. and establish those benefits. Now, that's easier said than done.
Let me ask this though, just to be clear. So even though I've been denied and I didn't appeal it, if I get new and material evidence, I can reopen my claim and actually win it?
That's correct.
Okay. And let's suppose I do win it and I go on the DOD website and it shows a stressful event. Does the start of my benefits start the date I reopened it in 2017, or does it go back to when I originally filed in 2005?
If VA does it correctly, and you actually obtain those records, DOD records that show the incident took place, that will qualify as what VA calls service records, not necessarily that particular veteran's service records, but service records in general, that show that the incident they originally claimed actually took place. And if that's the type of evidence that the claim ends up getting granted based on, then that benefit should go back to the original claim in 2005 that was denied. Now, VA gets that incorrect quite often. So that's just something people out there should keep in mind.
So we've been talking about this Freedom of Information Act request that we made, both for the Department of Defense records that was made previously, and also for the Freedom of Information of the number of claims. Where can veterans find that website and the information about the 100,000 plus claims?
We're going to put that on our website, the Chisholm and Kilpatrick website. We're going to put the link on there to the actual FOIA website for DOD. And so people should be able to obtain it from that.
All right, cck-law.com. Kerry, is there anything else you'd like to add?
I think so. If veterans out there have been denied, and they don't feel that they have the expertise to make this case back to VA, they should seek somebody's help. They can seek our help, they can seek another firm's help, they can seek a VSO's help, or they can educate themselves on how to do it themselves. But it may take more than just refiling that claim and pointing to that evidence. So, you know, keep in mind that these things aren't always easy, and if they deny your claim after you try to reopen it, you should not give up. Appeal that decision, particularly if you were one of those that were in that combat and VA can't prove it. That's where somebody like us can help. But having said all of that, let's say your claim was granted recently, based on the relaxed fear of hostile military terrorist activity criteria. But the one you filed 5 years ago was denied, and your benefits didn't go back that far. Because of those service records of the actual events that took place, you can request an earlier effective date based on that new evidence to get the benefits that you're now getting to go back to your original claim. So it doesn't necessarily apply just to people that have been denied and still are not getting those benefits. It could apply to people that are now getting the benefits that were initially denied.
So there's two things to think about. One is, can I prove my case with these new records from the Department of Defense, and did VA do the right job when they assigned the start date, what they call the effective date, for when the benefits start?
I think that's correct, yes.
Okay. Thank you very much for your time. This is Robert Chisholm and Kerry Baker from cck-law.com. Thank you.